Welcome to this presentation relating to Chapter 8 of our textbook. We're going to discuss the topic of property today, and we're going to break down the world of property into three different types of property: real property, personal property, and intellectual property. So let's get started. So we have three definitions here that we'll be using throughout this presentation. The first that we're going to talk about is real property, and here we have a definition, and as you can see, it is in red. So it's going to be a vocabulary term, I'm sorry. Another term for real property is realty. You may have seen that if you've seen real estate companies. Many times they're called realty companies. And when we think of real property or realty, we're talking about land, ground, immovable stuff. We're also talking about stuff that is attached to the land. So this would be a building, trees, things along those lines that can't be moved without great effort. A mobile home, for example, is not part of real property as long as it is mobile, but once it becomes permanently attached to the ground, then it may well become real property. And when we talk about real property, there's a bundle of rights that can flow from one's relationship to real property, and we'll talk about the various permutations that we have with that. We'll also discuss briefly personal property, and personal property is stuff. It's goods. We'll talk when we get to the contracts chapter, we'll talk about it being goods. But what it is it's stuff that isn't real property. It's stuff that can move. So real property can't move, it's permanent. Personal property is movable. So this is the point of difference between real property and personal property. And then finally we have intellectual property, and these are ideas, things in one's mind. And the thing that distinguishes personal property from intellectual property is that personal property is tangible. You can touch it. Whereas intellectual property is stuff in one's head. You can't touch it. It's ideas. So you can see each one of these is distinct from the other. Well, let's get started talking about real property. Okay, so there are kind of two important categories or bundles of rights that we think about when we talk about real property. One is the ability to say, this is mine and you can't have it and you can't use it, or you can only use it to this extent. And then, you could say it's the right of exclusion. Then the other kind of important bundle of rights is the ability to convey it or sell it or give it away to somebody else, to have it stop, be yours totally, and become someone else's. Usually, of course, this is an economic arrangement where you're selling the item, but it doesn't have to be. It could be what you choose to do with it after you die, or could be a gift of some type. So it has to do primarily, we think of property rights as how we relate our property to the outside world. But, when we talk about property rights, it isn't the case that we are the only people who have rights with respect to our property. Even when we have the maximum amount of rights with respect to real property, the public, the government is usually what we think of when we think of public, also is going to have some rights with respect to it. One thing that we'll see is that the government has the right to take our land. We've talked about this when we were in the constitutional chapter, the just compensation clause in the Constitution. This gives the government the ability to say, we need your land more than you do. They might need it to build a school or a highway or an airport or a governmental building. They might need it to build a railroad. Lots of different things can be done with the power of eminent domain. Of course, there has to be just compensation, the fair market value of my land. I have to be paid if I own the land and the government wants to take it. Unfortunately for me, though, there really isn't anything I can do to challenge the government's right to take the land. The only thing that I'm able to challenge is the amount that I'm going to be compensated for that taking. Of course, the government also has the ability to regulate the land. Extreme regulations that kind of strip the economic value of my land, might actually be qualified as a takings, which might allow me to receive just compensation for it. But usually regulation falls short of that extensive and interference with my property rights. And the government does have the ability to significantly regulate, assuming that there's a logical reason that it wants to regulate, to the extent that my property rights are limited, but they're still there. They still have economic value. And if they do continue to have economic value, I'm probably not going to be able to successfully sue the government under a just compensation / takings clause argument from the Constitution. And then, of course, this is probably our greater concern. The government has the ability to tax it. Of course, property taxes, especially in Texas, are a significant part of the burden that a property owner has with respect to his or her land ownership. And so that's something that we need to be aware of as we decide how we're going to handle our bundle of rights. We also have at least that bundle of responsibility with respect to our land. So when we talk about real property rights, what do those rights look like? Well, it's very, very expansive in the United States, and even especially in Texas. I guess that's not a big surprise. We're primarily a rural state, and the connections that people have with their land run very deep. I'll share a little story. I'm an eighth generation Texan, and my grandfather was visiting me one day when I was still a single person, and I had bought a house in Plano, and he with my grandmother came up to visit me. And he was looking around the house, and it was a small little tract house, no big deal by any means, but he was very impressed that a single woman was able to buy a house like this. And so he turns to my grandmother and he says, "Well, I think Cindy's going to be able to find a husband now." He was persuaded that once I had a dowry, once I had property, the young men would be lining up to marry me. Anyway, that was his philosophy about that there wasn't really anything in his mind as valuable as land. Cash and other things are all lovely and nice, but there's something just different about land. Anyway, that's a very common view that people in rural parts of the country, and this is probably international, have about land, and certainly it's a value that many, many Texans have had. And so it's not surprising that the bundle of rights that we give landowners in Texas is very, very broad. Okay, so let's look at those bundles of rights. Well, one is that we have not just the dirt underneath our toes, but we also have the air above our heads. Our property rights extend all the way, I guess, to the moon. That seems a little silly to say, but they keep on going, up into as high up, I guess, as we can build and as we can use that air. We own that airspace above us. But it's not just above us, it's also underneath our feet. It's not just the topsoil, it's not just 6 inches or 6 feet down. It goes all the way down as far as we can drill for water, for example. Maybe there is a underground aquifer underneath our land. Well, that water is ours. I say it's ours, and it is ours, but that's a little bit misleading perhaps. We have the right to use the water underneath our land, but we can't deprive other people downstream of the rights to their land. Not land, to their water. Water flows, and if I happen to have land either that flows above ground or flows underground, I don't have the right to dam it up and interfere with somebody downstream their ability to use that water. I can use it, but I can't abuse it, in other words. And then finally, I have the right to minerals underneath the ground and, of course, on the surface of the land. This is not, these first two rights perhaps are not that unusual, but having mineral rights can be unusual in other parts of the world and even in other states. We have a very broad understanding in Texas that, in theory, our rights extend all the way to the core of the earth. And if there's some type of oil or diamonds or gold down there and we can get it up, then it belongs to us. In some countries, it actually belongs to the government, and the government can come in and take that resource, but that's not how it is for us. The Texas law about especially oil and gas issues is pretty unusual. If you've dealt with oil and gas issues in other states, but not in Texas, many of the assumptions that you'll have won't prove to be correct here. A lot of the reasons that we have or what the reasons that our oil and gas law works differently have to do with historic reasons. When oil was discovered here, what the scientists' understanding about how oil was stored, and all those physical issues, and also about the technologies that existed at the time that oil was being, quote unquote, harvested from the ground. And so as a result, some of the legal principles that we have in Texas are a little bit different than they are elsewhere. In fact, fairly different from the way they are elsewhere. But the bottom line is, if there is oil underneath my ground, or diamonds or rubies or whatever, I have the right to extract that and to get the profit from that. So we have been acting like I own everything about my land. And I may well own everything about my land, but I may also not have all of the full bundle of rights. For example, I may have the surface estate. So I may have the right to the actual land, but I may not have a right to the mineral estate. In Texas, these are often separated. You might own the surface estate, meaning you can put a building on it, you can grow crops on it, you can use it for your entertainment, but the minerals, the items, the stuff that is underneath the ground might belong to somebody else. That person might own the mineral estate. When the two estates are separated, the person who owns the mineral estate obviously needs help to exercise his rights to the mineral estate. And so the surface estate owner does have to give him what you might call an easement. We'll talk about that in a second, to get to the mineral estate, because obviously you have to go through the surface to get to where the minerals or the oil might be. So let's talk about whether the owner has the whole estate or just the surface estate, what those rights might look like. Well, when people talk about buying land or buying a house or something like that, typically what they mean when they use those terms is they mean that they plan to acquire a fee simple absolute. That's the common law term for the most expansive bundle of rights that a property owner can acquire. This is the most that he can get. It can be inherited, it can be sold, it can be leased, it can be given away. It has every aspect of ownership and possession that is recognized under the common law for owners to have. Another type of estate that a person can have that is not a fee simple absolute is a conditional estate. We will talk about this type of estate when we talk, or not estate, but we'll talk about the idea of something being conditional when we talk about contract law. So this will be an idea that comes up more than once in the course. In this context, conditional means pretty much what we mean in everyday conversation when we say something has a condition. You know, I will hire you on the condition that you pass your background check. What does that mean? Well, it means that if you pass your background check, I will hire you. If you don't pass your background check, I will not hire you. That is a condition. It has to be satisfied in order for something else to happen. if A, then B. A is the condition, B is the result. So you can have a conditional estate in that way. If X happens, then B, and B is your estate. So in other words, when that exists, A hasn't happened yet, so you don't yet have an estate, but you're hopeful that you will. For example, if A dies, then you have a fee simple absolute. We don't have it now because A is still alive, but when he or she dies, that's when you get your fee simple absolute. Well, right now you have a conditional estate. It can happen the other way too, though. Um, it could be if you, let's say, your mother, let's say your grandmother leaves you some land and she wants you to get married by your 30th birthday. And so it might be a conditional estate. You have a conditional estate until your 30th birthday, which will become a fee simple absolute if you're married on your 30th birthday. If you are still single on your 30th birthday, it will go to your awful cousin Harold. And so that will be a conditional estate that will expire if some event hasn't happened. There's also something called a life estate, which is a special kind of conditional estate. It expires when you expire. You might say, well, that's not too much of a hardship for me because it's gone once I die, and that's true. But you won't have the ability to leave it to somebody else. Also, it's pretty hard to transfer that or to liquidate that estate. Let's say that the piece of property you have, its inherent value, if you in fact had a fee simple absolute, would be $100,000. When you just have a life estate, it's going to end when you die, whether you still own it or whether you have transferred that interest to somebody else, because the most estate you can transfer is the one that you own. So let's say you're 50, the owner buys it, probably thinks, I'll have maybe 30 years of use of it, and then it won't be mine once this person dies. And of course, they could die tomorrow. And so there wouldn't be a lot of people who would be interested in purchasing under those circumstances. And even if they would purchase, they certainly wouldn't pay you $100,000. Maybe you could get, 50 or 30 or something like that. So you can see that a life estate is significantly less valuable to you than if you had a fee simple absolute. It's not unusual to see life estate situations when a married couple, maybe we'll say the husband, had separate estate at the time of the marriage, or maybe he inherited property. He dies before his wife. He wants to take care of his wife, let her remain in the property, but he wants to establish who's going to inherit the land upon his wife's passing. He doesn't want to leave that to his wife. Perhaps he has children from another marriage that he would like to leave this property to. Who knows? Anyway, so she's going to be able to stay there until she dies, and then it will revert back to the original owner's estate for distribution at that time. Now, if I have a life estate, I do have obligations to the next person who's going to inherit it. So let's say in my property that's worth $100,000, there's a small cottage on it. Well, I need to, make sure that it doesn't get termites, that the roof is maintained, that the house is maintained in a structurally appropriate manner. Obviously, if I had a fee simple absolute, I wouldn't have to do anything because it's all mine. It could fall apart. I mean, there may be rules about building safety, but other than those things, let's say I live out in the country, nobody cares whether my place is a eyesore or a fire hazard or whatever else it might be. I can do whatever I want to it, but not if it's a life estate. I have the obligation to maintain that value of the property while I am enjoying my life estate. Another interest is a future interest. Many times this piggybacks upon the life estate. So again, let's say I'm the husband. I inherited this land from my parents, so it's my separate property. I leave it to my wife upon my passing. but I give her only a life estate. She lives 10 more years. Then upon her death, it reverts to my estate again. My estate provides that it goes to my younger sibling, George, at that time. Well, George, at the time that my wife got the life estate, he got a future interest. He doesn't he owns that future item, but he can't possess it at this time. It is true that he could sell his future interest. For example, he might get together with my widow and say, hey, I guess it'd be sister-in-law, right? Hey, sister-in-law, um, your life estate isn't worth that much. My future interest isn't worth that much. But if we combine the two, we have a fee simple absolute. And it's a lot easier to sell that interest than it is the two pieces of the puzzle. And so that can be a way of, solving the problem of being able to liquidate the asset. Then, of course, we'd have to decide, well, how much does George get and how much does the widow get? They may have a disagreement about how to apportion whatever they are able to acquire through the sale. Sometimes the interest is not an ownership interest, but it is a possessory interest. An example of that is the leasehold. This is when we have a lease, as you can tell by the name. Now we have an owner who may have a fee simple absolute. He is leasing the land to someone else, and we call the landlord or the owner the lessor. And you can see we have this OR ending, which means this person is doing the less or the lease. And then we have the lessee. This is the person who is receiving the lease. The lessee doesn't have an ownership interest. His interest is in possession during the period of time that the lease provides. So it's never going to become an ownership interest. The landlord will continue owning. Now there can be hybrid situations where you're leasing with the option to buy or something along those lines. It's not that that's impossible, but your standard lease is not that type of arrangement. Then we have situations where we don't have an ownership interest and we don't have a possession interest. We've got something else, and we have 3 examples of this. Let's take on the bottom 2, and then we'll do the easement last. A license is the right to temporarily occupy some piece of property. We usually think about a license as the right to, say, go to that rock concert. The seat that I have the right to be in, I'm only going to have the right to be in for a few hours, and then I have to vacate it. I can't arrive much before the concert begins. Oh, excuse me. And I can't stay much after the concert ends. And if I misbehave or do something that I'm not supposed to while I'm there, I can be evicted. You could say that a license is like a really, really, really brief leasehold, I suppose. Most people don't use that terminology, though. Then we have profits. Profits are not very common these days. This is the idea that I have the right to go onto someone else's land and take something away. Typically, this is something that has economic value. That's the term profit. I can make a profit off of it. For example, maybe you have apple trees on your land, and so you give me the right to go onto your land to harvest the apples, and I get to take that away, maybe sell it or something along those lines. That's what a profit is. Licenses are common nowadays. Certainly going to the movies or something like that is a license. Profits aren't very common. Easements are also, easements are more like licenses in that they're very common. And this is a right, and we can see the word irrevocable, and that's a difference between, easement is irrevocable, a license is revocable. An easement is a right to use another person's land for a specific purpose, but it's different than a profit because this is the difference between it and a license. It's different than a profit because you can't take anything, whereas here you can take. So this is oftentimes, imagine that you're the public utility and you need to have a meter reader go out to read the meters on somebody's land to make sure that they are paying the right amount for their utilities. Well, you have to actually go onto the land and have somebody eyeball the meter. Well, if you didn't have the right to go onto the land, you'd never be able to know what the meter says. So that's an example of an easement. Let's say the cable company needs to repair a line, or the electrical company, one of the power lines is down and they need to go into your land to repair it. Well, they use an easement to do so. Here's an example of another scenario. This is less common type of easement than the ones I just described, but especially in rural places, this isn't infrequent. Imagine here that we have a river or a lake, and we'll imagine that there's a river or lake over here too. So this is the road. The only way, I live over here, the only way I can get to the road is through Bob. We'll call this guy Bob's land. And so I need to get an easement that will allow me to motor through his land so I can get to the road so I can go to town or do whatever other things I might need to do off of my property. I can't, ford the river, I can't ford the lake. This is my only path. And so I'm probably going to give Bob some amount of money, or maybe offer to help him do something on his land to compensate him for the use of this kind of right-of-way. He's not going to want me to do any more damage than we can, that thing can happen. So I'm not going to, drive all over his land and do whichever way I want to. No, he's probably going to say, hey, take the shortest route, or if he doesn't want me to take this route and he would like for me to go all the way over here, well, then that's what I'll do. And so that's what an easement is. So let's talk about how we transfer real property. Let me just for a second show you a picture in the textbook. Here is a picture of how this can proceed. Here we go. Okay, so the grantor is the seller, the person who is granting the land. The grantee is the person who is receiving the grant. Again, the OR and EE ending. So the grantor has the deed, he executes the deed, he delivers the deed to the grantee accepts the deed and then records the deed at the county office. The reason that the grantee wants to record the deed is so that if the grantor is a slippery fella and completes this transaction with the second grantee, and the second grantee records the deed before you, the first grantee, can record the deed, then the county office will show that the second grantee is now the owner. And so the first grantee, will be in a very difficult position to prove that you are the true owner. So that's an important step of the process. So here we go. Grantor executes the deed. Again, this is the seller. Sorry about that. Seller. The grantor delivers the deed to the grantee accepts the deed, the grantee records the deed, which is required to protect the grantee's new interest, and it's recorded in the county office and in one of these books, one of the deed records. You've probably heard of something called squatters' rights, and I wanted to kind of explain how squatters' rights work. The legal term for squatters' rights is adverse possession. And this is the right of somebody to acquire an ownership interest in land that they have not purchased and it hasn't been bequeathed to them or given to them. As far as I know, all states have, or I guess I say most, so I won't say all states, but certainly Texas has a mechanism to do this, where um, a way for somebody to acquire an ownership interest without actually buying it from the owner. And there are three things that this person has to do in order to um, acquire an ownership without actually buying the land. The first thing that he has to do is he has to actually use it as if he owned it. He is essentially pretending to have a set of rights that he doesn't. That's what we mean when we say actual. Now, if I am claiming or adversely possessing something, but I only visit the land once a year, I'm not actually using the land as an owner would use the land. And so I haven't completed the first task. Now, it probably doesn't require that I be on the land 24/7 for the entire period of time that I have to under the statute. I can leave from time to time because, I mean, that's what owners do. It's pretty rare that an owner never leaves his land. But I need to stay there, as frequently as you would expect an owner to stay there. It also has to be open. I can't be sneaking around. We had a rash of attempted squats in Collin County back in the late 2000s, or about right after we had all the foreclosures when people were upside down in their houses and they let the houses go back to the bank. And banks had so many properties uh, that they weren't really managing them in all cases as well as they ought to. And so some people just started moving in and they would live there just as if it were their house. They turned on utilities, and so that would be actual, right? Because after all, if you have a house, you're going to turn on your utilities. You're going to do the things that owners would do. But let's say that I was one of these people squatting and I never turned on my lights at night and I never parked my car out front of my house and I never uh, would be out doing yard work or things like that. I was trying to be as secretive as possible so the neighbors would think that the house was unoccupied. Well, then I'm not doing it in an open way. A true owner is not acting secretive. He has nothing to be secretive about. He owns the property and he's going to use it as he sees appropriate. And so I ought to be having the lights on whenever I want to have them on, which is going to sometimes be at night. I ought to have a fire in the fireplace sometimes. I ought to be out taking care of the lawn and walking around the neighborhood and doing all the other things that the owner would ordinarily do. And this last one is perhaps the most important. It has to be notorious, and I love this word here, notorious. It sounds kind of shocking and scandalous, but it doesn't mean anything shocking or scandalous here. You don't have to be running a brothel or a gambling establishment or anything like that. In fact, you shouldn't be doing that, most likely. But this would be that you are doing it without the owner's permission. Let's go back. We talked earlier about the whole leasehold idea, and we said how the lessee, the tenant, isn't going to acquire an ownership interest. And it's not possible for a lessee to squat because even though he probably is being actual and open, he's not being notorious because he has the lessor's permission. After all, there's a lease, so this person has the permission to be here. So in order to start the clock ticking on your adverse possession, you need to have no legal right to be there. You can't even have the permission. The owner, if the owner has said to you, oh, sure, you can stay in my house for a little while, and you move in, well, guess what? It's not notorious. You have to do it in such a way that the owner has not approved it and would not have approved it if he had known about it. We have a variety of statutory periods in Texas. I'm just going to flip through these really quickly so you can see under certain situations it's 3 years. Under other situations it's 5 years. Under other situations it's 10 years. Under other situations it's 25 years. You aren't required to know anything about this other than the fact that the time periods vary greatly. I would say that nowadays it's pretty much impossible or virtually impossible to expect to adversely possess land in Texas. Possibly in some rural area you could get away with it, but in a place like Collin County it's just not a realistic thing. But in any event, people can try, right? Okay, so we talked before about the power of the government. Let me just flip back and we can see this. This is like on our second slide or so. We talked about the power of the government to take land with just compensation. Well, now we're going to flesh that out a bit. Of course, we had the takings clause, which is also called the just compensation clause. And that is the right of eminent domain. It's the right of the government to come in and say, yeah, we know this property belongs to you, but we want it for ourselves. We want to build that school there. And in fact, the government can use its power of eminent domain for a private company if the whatever that private company is going to do is going to benefit the larger community. I'll give you an example of something that's gotten a lot of publicity in Texas, and that is the idea of us having a bullet train that will connect Houston and Dallas. We don't know if it's going to happen at this point, but a private entity is buying up land between the two cities so that they could put this high-speed rail line in effect. Many of the landowners along this path would prefer not to sell their land. But because this private entity has that power of eminent domain, the landowners don't have the ability really. I mean, some of them may be contesting the use of eminent domain, but very likely they won't be successful. They can, of course, quibble about the amount of compensation they're going to get, but the right to actually condemn the land for the government purpose is probably not going to be a very successful avenue for them, because there will be a benefit to the public if this project goes forward. So what is condemnation? Well, it's the same process that we've talked about. It's the transfer of property made against the protest of the property owner. The property is being condemned so that it can become the property of someone else. Here is the Texas constitutional provision about this. And of course, we've talked about in the constitutional chapter about the government the federal government aspect. And you can see a key word here has to be with adequate compensation. So we have that same idea in the Texas Constitution as we do in the federal Constitution. And then here is some of the details of the process by which a governmental entity can condemn property. And this is again part of the Texas Property Code. So now we're completed with real property section. Let's go on and talk about personal property. And again, let's just keep the two concepts straight. Personal property is movable. It is stuff. It's another term for it. You can touch it, usually. They come in two flavors, tangible and intangible, touchable and not touchable. But most of the stuff we think of as personal property is tangible or touchable. Obviously, there's a million different things that fit into this category: books, furniture, cars. Intangible stuff are things like bank accounts, stocks, insurance policies. But even these intangible things usually have a tangible aspect. I mean, after all, when you have a bank account, you get statements, right? You get a stock certificate. You have the piece of paper that's the insurance policy. So usually there's some sort of writing associated with something that is even intangible. And so it's really not completely intangible. we'll talk about, when we're talking about intellectual property, we'll talk about things that truly are intangible. These are kind of hybrids to some extent. So when we talk about ownership, we're not talking about deeds now, we're talking about titles. Title is the manifestation that we have for an ownership interest. And most of the time when we sell something or give something away, when we transfer title, is another way of putting that, we don't actually have a formality. If I were to sell you a pencil and you were to give me 20 cents for the pencil, well, I don't give you a receipt of any type. I just give you the pencil and you give me the money and we're done. Most of the time it's that easy. Even if it's something rather expensive, such as, let's say I'm a jeweler and I'm selling you a $20,000 ring. Again, you're going to get a receipt, but that's really not title. You get the ring and I get the money, and that's kind of how things go. But there are some things that we do have a more formal process for, where we actually have a written title. And here's an example. We do them with cars. So there are the cars and boats, and there's a few other things that we register it so that there is this paper trail of titles. It makes it more difficult for people to steal the car, or at least to steal it and to resell it. And that makes sense when something is very valuable and also very mobile. So if I want to engage in a transaction, if I want to transfer title, I can do it via a sell. I can sell it to someone, or I can give the item as a gift. Those are examples of voluntary transfers. So let's talk about how a gift works. Well, there's kind of two categories of gifts. One would be during my lifetime. Hey, Bob, you're my buddy. I want to give you this pencil. Well, that's called an inter vivos transfer. I'm alive. You're my buddy. I want to give you something. There's another category, though, and this still happens during my lifetime. It's a causa mortis. And that's when I am thinking I'm close to death. Maybe I'm very old, maybe I'm very sick, and I decide that I want to start distributing my assets. I don't want to rely upon my will to take care of it. I want to transfer it right now. And so I say to Bob, Bob, I'm about to die. I have this pencil here. I'd like for you to have it. That is a different type of gift, because it's always possible that I will be healed. I thought I was going to die, but nope, didn't die. Back to being in good health. In that situation, I have the ability to revoke and say, hey, you know what? I only gave that to you because I thought I was about to die. And look, I didn't die after all. So my circumstances changed, and so I want that back. I can't do a take back if I have an inter vivos transfer, because I was not making the transfer because I thought I was about to die. So that's a difference between these types of transfers. So, but whichever type of transfer that I'm doing here, whether it's inter vivos or causa mortis, a gift has to have three elements. The first one is I have to deliver the gift to the recipient, to the person to whom I am giving the gift to. As soon as he or she has the gift, that's the moment it becomes irrevocable. If it's an inter vivos gift, I can't come back after I've given it to them, after I've delivered them, and say, I'd like it back. Well, I can say that, and certainly the person to whom I gave the gift to can give it back to me, but he can also say, not so much. It's mine now. Tough for you, but I'm not giving it back. If it's inter vivos, I'm out of luck. I shouldn't have delivered it until I was sure that I wanted to transfer title. So it's the delivery that makes it irrevocable. What are some other aspects to a gift? Well, one is that I intend to give. For example, if I was just going to loan it to Bob, hey Bob, here's a pencil, maybe I meant you can borrow it for a while. Maybe I meant I'm giving it to you forever and ever. it may be unclear based upon the words what I meant. So you have to look at what's the intent, what's the totality of the circumstances, and how would a reasonable person have interpreted that? What's the objective read of this particular situation? So sometimes there's an issue about how long I wanted to surrender the rights, forever or for just a period of time. Another could be, did I really intend to give it, or was I thinking Bob was going to buy it from me? So maybe say, here's a pencil, Bob. I'd like 25 cents now. Well, under those circumstances, maybe I've given it to Bob thinking he's going to look it over and evaluate whether he wants to pay 25 cents for it or not. He thinks I just gave him a gift. Well, if I turn around and say, well, where's my 25 cents? That suggests I did not have a donative purpose. And then finally, the recipient has to accept it. If Bob doesn't want the pencil, then I haven't successfully given a gift. Obviously, sometimes when people get gifts, there can be tax implications or other responsibilities associated with it. And sometimes the recipient doesn't want those. And so he or she is free to say, thanks, but no thanks. So we've been talking about voluntary, let me go back here, voluntary transfers. And we've talked about how they can be a sale or a gift, but there's some other voluntary transfers. One is abandonment, and this is when I just say, I don't want this anymore. Maybe I put it out front of my house hoping someone will take it. Maybe I leave it in a public place hoping somebody will take it or address whatever that thing is. And let's say I leave something on my front lawn and somebody comes along and says, yeah, I'd like to have that. Well, now I no longer own it. The person who now possesses it owns it because I, the original owner, abandoned the item. Another possibility is that I lose something, and this is an accidental scenario. I didn't intend to. This is the difference. Discard suggests a certain level of intentionality, and here we have an accident. So this is the difference. In both cases, the owner is no longer having possession of the item. In this first case, it's intentional. He doesn't want to have possession of the item. Here, he would like to still have possession, but he doesn't. So when it's a loss situation, this is the idea of finders, keepers, losers, weepers. Well, that's pretty accurate. The new possessor does have the best title for the item, the person who finds it, except sometimes the original owner will have rights superior to the new possessor. That's a possibility. And then finally we have mislaying. This is somewhere between abandonment and loss. In this situation, the owner intentionally leaves something, so it's sounding a little bit like abandonment, but then he forgets, which sounds a little bit like the accident. So he's planning on coming back, but he's leaving it for a time. So it's almost between these two, right? And under these circumstances, the owner where the place was left becomes the new owner. So if I intentionally leave something at your house and then forget where I left it, then the item becomes yours. At least that's likely to be the result. And these again are involuntary transfers. You can see in each case, I didn't really want to give up the item. I guess maybe I did want to give up in the case of abandonment, but loss and mislaying, the original owner, didn't intend to give up title, but I did anyway, perhaps. So let's talk about some other ways we can acquire title other than receiving it as a gift or stumbling upon something someone else lost or abandoned or mislaid or buying it. We could also create something. If I paint a painting, that item becomes mine. It didn't exist in the world before, but now it does, and I created it, so therefore I owned it. Now, of course, if I had a commission, let's say I'm an artist, professional artist, and I have received a commission to do that, then it really isn't I don't really own it. It belongs to the person who commissioned the work. But let's assume that I was not working under commission. Another way that property rights can be acquired just through court order. There can be a lawsuit about who actually owns that item, and if the court resolves it in my favor, then I have a title because of the court order. A third way would be through confusion. Let's talk about the idea of fungible goods. Again, this is a vocabulary term, so you'll want to remember what this word means. So what is a fungible term? Well, or what is a fungible good? It's a good that is indistinguishable from other goods in its class. So one grain of wheat looks just like another grain of wheat. Or, I mean, they're not identical looking. If you were to get a magnifying glass, you'd be able to see small differences. But as a practical matter, they're identical. And this especially applies to commodity things, oil, uh, uh, sorghum, tomatoes, all of those things. When you get lots of little pieces and you add them all up, and each one of those little pieces, it literally looks just like all the other little pieces. We call those fungible goods. They're interchangeable. One is just as good as another. And so if I have 100 bushels of wheat, and you have 100 bushels of wheat, and somehow or another our bushels of wheat get confused up with each other. And so now we have 200 bushels of wheat. Well, we're just going to separate them, and you get 100 and I get 100. It probably won't be exactly the same 100 that grew on my farm, and the 100 bushels you get won't be exactly the same 100 bushels that grew on your farm. But it doesn't matter because it's wheat, and one bushel is just the same as another bushel. And so, yes, in some sense, title did transfer from you to me and from me to you for some of those bushels. But it's a wash, and so it's fine that we had that happen. So now we have completed real property and personal property. Now we're going to go on talk about intellectual property. This may be the one that is less familiar to you. But it's an interesting area, and it's certainly one that is vitally important to our economy. Again, this has to do with stuff in the mind. At this point, we've been talking about stuff we can touch, but now we're going to talk about things that develop in the mind, and also that has to do with creativity as opposed to physical effort. Here with personal property, if you created something, it had to do with blood, sweat, and tears. If you were making a sculpture or building a car or whatever the thing is. I mean, yes, there may have been some creativity and brainstorming with it, but it required physical human effort. And when we're talking about intellectual property, we're talking about more of the intellectual side of things. There's going to be basically 4 categories that we're going to talk about in the way of intellectual property. Trademarks in a subcategory called trade dress, copyrights, patents, and trade secrets, which are fairly analogous to patents. You can see here is a series of trademarks. When you see these terms, this little picture is sufficiently clear that you can actually see the words, but even if you couldn't see the words, for example, this one would be very identifiable. This is McDonald's. You don't really even need to see the McDonald's. You probably can't really recognize the word Wendy's here, but it's Wendy's because of the shape of it. And others of these are familiar to you. If they have a Nike swoosh here or not. Valvoline, you can probably recognize this one. Mercedes, Direct TV. There's several that are pretty recognizable. I'm not seeing the swoosh here, but these are trademarks, and they can be a very effective marketing tool. They help consumers recognize the product from a significant distance away, and they give value to the product. So what is a trademark? It is a distinctive mark, word, design, picture, arrangement used by the manufacturer to cause the consumer to identify the product with the producer. Okay, so imagine I am driving on an interstate. It's getting to be about dinner time. I've been driving for a while. I'm thinking the next couple of exits, I'm going to get off the freeway, go through a drive-through, grab something to eat, get back on the road. And so as I am approaching an exit, I see up off of the exit, off of the feeder road, a big yellow M. I know that's McDonald's because of my life experience. I think to myself, Big Mac sounds like a good choice. The food is reliable, the line will be quick, it won't be expensive, it makes sense to me, I'm going to go for that. So that trademark has helped me make the decision. If I had seen a big yellow G in the air that stood for, Groover's Diner or something, I'd be like, well, what's that? Is that a gas station? Is it a convenience store? Is it a restaurant? If it's a restaurant, what food do they serve? Is it going to be reasonably priced? Will it be fast? Will it taste good? Will it be something I can eat while I'm driving on the freeway? I just don't know. And as a result, I don't want to commit to that. I'm going to drive until I see something that is very identifiable to me, that is going to, I'm sure, meet my needs. Because after all, I'm trying to make some miles here, and the last thing I need is something that's going to interfere with my progress. So a trademark has to be registered with the federal government in order for the person who wants to have the trademark before he can exclude other people from using it. A term related to trademark is trade dress, and this applies to the overall appearance and image of the product. It is also entitled to protection. And here's an example of what you might see as an infringement issue. Obviously, Dr. Pepper is a trademarked name, and then the trade dress would also be protected. And then we have this other company that is having a product called Dr. Publix, which I guess Publix is probably the grocery store chain. And you can see there's lots of things that are similar about it. The beverage color is the same. You can see that the wrapper is about the same color. The writing is in white letters. It's called Doctor, and it starts with a P. It's about the same length as Pepper. You can see a lot of similarities, but there's some differences too. The cap is black here versus white. There's no yellow writing here, and the word Publix is different than the word Pepper. There's no period after doctor here. There is a period here. So there's some differences and some similarities. There's no white band at the bottom and at the top. So there's some differences and similarity. The trade dress is similar but not identical. What the court would do with that, it's unclear to me, but that would be something that the parties could debate. So that's our discussion of trademark. Let's go on and talk about our second type of intellectual property, copyright. Copyright, what's the definition? It's the protection of an expression of creative work. And this can be in tons of different ways. It could be I'm a novelist or a nonfiction. Just because we're saying it's creative doesn't mean that it's fictional. It could be a magazine article or a newspaper article or a scholarly article. It could be a musical composition. It could be the recording that I make of me playing a musical composition on the piano or the violin or the flute or the oboe or whatever. Or it could be me singing. And it doesn't have to be a good performance. I'm an awful singer, and yet if I were to record my voice singing a song, as awful as it would be, I could copyright it. The law doesn't have necessarily an artistic sense or taste about it. It would say that it was subject to copyright even if it were really, really bad. Similarly, plays, motion pictures, sound recordings, anything that has that creative impulse associated with it. In order for it to be eligible for the copyright protection, again, copyrights don't have to be registered, You just, well, we'll talk about what you have to do to protect it in just a second. There are 3 things that copyright has to have. It has to be fixed, meaning that it's set in one style of performance. So, for example, my general style of playing that musical piece, let's say I have a particular spin on it, that I hold my half notes unusually long, and I do a little bit more staccato with my quarter notes, and uh, I do more uh, dramatic passages or whatever. Anyway, all that is kind of my artistic statement. I wouldn't be able to copyright that. I could copyright a particular performance that I make that might have all those characteristics, but I wouldn't be able to copyright my style. Someone else could perform that same song in my quote-unquote style, record that, and also get a copyright, even if it sounded very similar to my style. At least potentially they'd be able to do that. It has to be original, so I can't take someone else's music and re-record it with their performance and consider it my own. Or I can't take a book that was written by somebody else and just type it up into a new manuscript and copyright it. That's not my original work. Finally, it has to be creative. It has to have something of me in it. Again, it doesn't have to be fictional, but it doesn't have to be good, but it has to involve something that I've added to. So if I'm taking quotes from this source and quotes from that source, and there's nothing me about it, then it's possibly not copyrightable. Now, you could say the particular quotes that I'm taking are, my choice of quotes. I quoted from this author here and that author there, that involves some creativity. So there might be an argument along those lines, but there has to be some argument that I am adding something to the copyrightable document in order for it to be copyrightable. Okay, so the idea of copyright is not new to our society or to the 19th or 20th century. It's something that existed in the common law, excuse me, pretty much forever. So that we don't rely upon a statute necessarily to establish these rights, although we do have statutes in the United States now. But the idea existed before it was statutory. It's important to mark things that you want to assert a copyright on by using the little symbol here. By the way, when you use the symbol, it's quite easy to do. Let me just show you how you do that in Word. Let me see here. You do open parentheses, a C, a close parentheses, and you get that circle C, that copyright sign. You can also just write out copyright or an abbreviated form. So you have to habitually do that in order to preserve that copyright. If you don't leave these marks, then your work can fall into the public domain, and that means other people don't have to pay you to use your material. You don't have an active copyright for that item. If you do maintain the copyright carefully, good for you. It will be good for your lifetime plus 70 years. So let's say when you were 5 years old, you painted a finger painting, and you you followed all the procedures, you put the little copyright symbol on it, you wrote the date in which you published it, and you have your name on it. Your mother files it away in some drawer somewhere. You become a famous artist, and you live to be 105 years old. You pass away. That piece of artwork is discovered, and it's now 100 years old, and somebody wants to publish that, but they don't want to pay your estate. Well, they're out of luck. They need to pay the estate because that particular piece of artwork will be good for 170 years after the date that it was created, because you lived 100 years longer, after you actually created that particular artwork. And then, of course, it passes into the public domain after those 70 years. There's no way to reinvigorate those periods of time. If you have any background, say in theater, you may have from time to time done plays like Shakespeare or other classic works of literature like that. And certainly you can perform those because they're artistically very compelling, but also they're in the public domain, so nobody has to pay any money to Shakespeare or to Shakespeare's estate in order to use those plays. And so that's a benefit to using those items. But you know what? We can use items that are copyrighted to a limited degree without paying any money to the holder of the copyright. And that's because of our First Amendment rights, freedom of speech. And the doctrine that we apply here is the fair use doctrine. And this provides that a portion of a copyrighted work can be reproduced for these reasons: criticism, comment, news reporting, teaching, scholarships, and research. So research is, when you're writing your history paper and you quote from various books, well, guess what? You are engaging in research. When your teacher prepares things like this PowerPoint, and she may use items under the fair use doctrine. She may this quote here may have been taken from a textbook or something, and she's using it for the purpose of teaching. Let's say a film critic goes to a movie and takes a snippet of that movie from it to explain what he or she liked or maybe didn't like about the movie. Criticism and comment fall into that area. Or let's say there's a news story about a controversial new political book out there, but written by maybe a candidate for public office, and he or she says something controversial, and they want to run a news story about that. Well, that would fit into the news reporting aspect. It's important that the excerpt be brief, so it can't be, the whole book. Exactly how long it can be depends upon lots of different factors beyond the scope of this particular lecture, but it can't be a huge percentage of the initial work. So now we've talked about trademark and copyright. Let's talk about patents. So what is a patent? Well, it is a type of protection that protects a product, a process, an invention, or a machine, or a plant. Of course, here we have invention. That's what we think of when we think about patents. In order for a patent to be issued, it's going to have to satisfy three elements. Let's go back and look at copyright again so we can see those three elements. So it needed to be fixed, original, and creative, right? Fixed, original, creative. Well, here we need novel or new. Well, that's like original, right? So we see a repeat here. And we have non-obvious. You could say that this is maybe related to creative, I guess, a little bit. Maybe. And it also has to be useful. I don't really know if that's related to it being fixed or not. But these are the 3 requirements that we have for patent. It has to be new. So if it's an idea that somebody else has already thought of, too bad, so sad for you, you can't patent it. It's not at all unusual for one person to come up with an idea and another person to come up with the same idea, even though they have no contact with one another. The first person to file for the patent is the one who's going to get the patent, even if the other person actually thought of it before the first person, but just the other person just got to the patent office first. The item has to be useful. Just because you've come up with another way of doing something, if it's not better in some sense, the patent office isn't going to approve it. It also has to be non-obvious. You can't invent the wheel, something along those lines. Let me show you a resource. This is kind of a neat thing that hasn't existed for very long. Let's go to Google. This is Google Scholar. You go to it by scholar.google.com, and we're going to go to Articles Include Patents. And I am going to type in, first of all, I'm going to type in fishing pole. You can see all the different types of fishing poles patents that have issued. Different ways that this will hold a fishing pole in place, but see, we'll allow it to move up and down so the person can see when a fish is attached to it. Here's a fishing rack. We can see that there are 176,000 results under this topic, fishing pole. We can also do searches by the name of the patenter, and I'm going to use my father-in-law's name, Jerry Gruber. And here are his patents. We'll just pick up an easy one here. Cured blend of diene block copolymer. Yeah, sure. I know what that is. Obviously I don't. But if we want to just look at a patent abstract here, this goes in and explains all of the science behind it, all of the ins and outs of what's required in it. Very technical documents. Anyway, so that's what a patent application looks like. Let's say you are an inventor and you come across, or you come up with an idea and you think to yourself, I think I'm the first person who has come up with it. Well, let's skip ahead. Okay, so let's say you come up with an idea and you want to get a patent. Okay, well you certainly don't have to hire an attorney. You can try to secure a patent on your own behalf. It's probably a good idea to hire an attorney. An interesting thing about the patent bar is that it's different than most other bars that attorneys deal with. It is usually the case that an attorney who is admitted to practice in a particular state can practice law in any court in that state, even in federal court, because all he or she has to do is join the federal bar for that particular court, and it's usually not a big deal. But that isn't true for the patent bar. In order to appear in a patent dispute that is in front of the patent office, you have to have passed the patent bar, that test. And only practitioners typically who practice in this area sit for the test and would be able to pass the test. And so it's a pretty elect group. The patent bar is a federal bar, so once you're a member in all 50 states. So you wouldn't want to just go see any attorney for help with a patent. You'd want to see one who is a patent attorney. So when you go to see the attorney, and let's say you decide to hire him or her for the case, one of the first things that he or she will do is search to see if there is already a patent in the area. And that way he or she can quickly tell you, oh, we're so sorry, but your idea somebody else has already come up with. And the way, again, that attorney would search would be going through Google Scholar. And so let's say your idea was fishing hook. Let's see. You come up with the idea of a having various grooves on a certain place on the fishing hook. And, well, gosh, well, look at this. We found this patent application, and they already came up with that idea. And so your idea was really smart and awesome and tremendous, but guess what? It's not novel or new. We're sorry, it's new to you, but it's not new to the patent office, so you're not going to be successful. So that's the first thing the attorney is going to do. The attorney is going to look and see if anybody else has come up with the idea. Now, of course, there's a continuum. Some ideas can be really close, but not exactly the same. And so there is a judgment call. Well, I think the patent office will approve this one, or I don't think the patent office will approve this one. The patent office ultimately approves about half of the applications it receives. It issues a patent in about half the cases. It depends upon the circumstances what your particular likelihood would be, how close your patent application is to another previous patent application. Another challenge can be that you only see the patent applications of those patents that have already been approved. So it could be that a patent application was for your particular brilliant insight was filed just yesterday. Well, it won't be available on Google Scholar for quite some time, but it's available to the patent office immediately. So you don't have the ability to search everything that's out there. The patent office, of course, will evaluate the patent application and will ask you questions about it. And again, you can respond to those questions. And it usually takes about 2 years, and about half of all patent applications are likely to be approved. Let's talk about what you get when you get a patent. Well, unlike the copyright, which lasts for your entire life plus 70 years, a patent only lasts for 20 years. So it's a much more modest right. But as long as you have the patent, you have the exclusive right to sell, produce, and use the object of the patent from the date of application. So, as I say, you're probably not going to get your patent for about 2 years. So once your patent issues, then you'll have it for about 18 more years. You have the right, if you would like to sell your patent. And usually the way that this happens is that you sell the use of that. You can sell your patent completely, but in that way, you would get some kind of lump sum for that amount. But you could also sell the use of the patent, so that if, let's say, I invented this better fish hook, and so I sell the use of it to a fish hook manufacturer, because I don't have the infrastructure, the marketing system to effectively market, I might sell it to that person, and maybe that company would give me royalties as part of our agreement. Maybe I would get 10% of its sales on that particular item. That can be a way that it might be structured. Now, obviously, even though I have this monopoly of power, because I have the exclusive right to do things with it, I I have some limitations. It's not without any limitations. I can't use it for any legal purpose, and most of the illegal purposes relate to what is perceived of as an abuse of my exclusive power. Taking my monopoly power to extremes. And there are two common problems that come up in this area. One is when there's a tying arrangement, and sometimes these can violate the law. This is when I am the holder of the patent and I issue a license to use my patent, but only if the licensee agrees to buy some non-patent item from me. So let's say that I am selling fish hooks, and my fish hooks are wildly successful at persuading fish to stay on the hook. My fishing poles are no great shakes, but I'm unwilling to sell my hooks without the fishing poles. And so I insist that when anyone who wants to buy my hook has to also buy one of my fishing poles, whether they want them or not. That's a tying arrangement, and it may be unlawful. Cross-licensing can also be unlawful, and that is when there are two patent holders and they license the patents to each other, and as part of that license they say that each other agrees not to let anyone else license those particular patents. So they're kind of restricting the use of the patents in that way. So we've talked about trademarks, copyrights, and patents. Let's talk about trade secrets. Trade secrets are similar to patents. Let's look at the definition. It's a process, product, method of operation, or compilation of information that gives a business person an advantage over competition. Inventions and designs are trade secrets. Let's go back and look at what a patent is. Well, it protects a product, process, invention, machine, or plant. So we see product, process, invention, machine, or plant. We see product or process. So you can see there's a lot of overlap. So what's the difference between a trade secret and a patent? Well, first of all, trade secret is a creature of the common law. Patent is a creature of statute. So that's kind of the historical difference. But the big difference is you don't file anything to keep a trade secret. In fact, you can't file anything to keep a trade secret. You have to keep it a secret. That's the thing. And it has to be something that is being kept a secret. When you have a patent, by definition, you can't keep it a secret because you have to file this patent application. And while, so here, if we look at the this patent application for this particular item, if I was in the business of making fish hooks and I read this, I ought to be able to replicate your patent. Here, let's just view the PDF here. I can see where those little things are and come up with an insight about each one, about how I would replicate it. So any secret that I had about how this was supposed to work wouldn't really be a secret once I put this into my patent application. So you, by definition, don't file a patent application when you're doing a trade secret because you're giving away the secret then. So that's why Coca-Cola, there is no patent application for Coca-Cola's secret formula or for Kentucky Fried Chicken's 11 herbs and spices. If they were to file for one, the mere act of filing it would make the trade secret go away. And you actually can't get patents on recipes. So, excuse me, it would be pointless to even try to do that. So the secret to a trade secret is to keep it a secret. And as long as you keep it a secret, it'll be a secret forever. It'll be a trade secret forever. It won't expire after 20 years. So that's one of the strengths of a trade secret. There's no attorneys to hire, there's no paperwork to fill out, and it's never going to expire. The problem, of course, is that if somebody leaks it, if somebody tells the world the secret ingredients to Coca-Cola or what those 11 secret herbs and spices are for KFC, then at that moment the trade secret goes poof. And somebody could have the trade secret go poof 10 minutes after you've invented it. And you might look back and say, boy, I wish I had had 20 years to enjoy this. If I could have patented it, then I would have enjoyed that. But so you can see how a trade secret can last a lot longer or not nearly as long as a patent. As you can see, there's advantages to both, and businesses have to kind of weigh the advantages and disadvantages to whichever method they're going to consider. Another reason that sometimes the patent option isn't as good as the trade secret option is that, again, half the time when you file for an application for a patent, you aren't granted the patent application, and now you've given away through the patent application process, which is a public document, you've given away the secrets of it, and so now everybody really can read up on your secrets and do exactly what you thought was a smart strategy, and they don't have to pay you anything. But of course, the risk with a trade secret is that somebody leaks the information and there's nothing to protect anymore. So those are the ups and downs of the world of trade secrets versus patents. We have now gone through the 4 types of intellectual property: trade secrets, trademarks including trade dress, copyrights, patents, and trade secrets. We've also gone through the differences, what real property is, how we own things, how we transfer ownership, what those bundle of rights are. We've talked about personal property, what it is, and how we transfer rights with respect to personal property. And then we've discussed the 4 types of intellectual property. I hope this presentation has been helpful for you. If you have questions, please feel free to email me or come to my office hours or raise those in class. I thank you for your attention, and I hope you have a great day. Thanks.